Hello, welcome. Good afternoon, everyone. Thanks for joining us. My name is Kim Christian, attorney and partner at Russo Law Group. I'm here with Alex Nocerino, partner at Chopra and Nocerino, and we're very pleased to be presenting to you today Personal Injury 101 from Accident to Action. We think it's relevant. Anything can happen to us at any time. And I'm just so grateful to have Alex with me today so that we can discuss the process a little bit as well as some asset protection. Some of you have joined my webinars, typically know that I usually have a PowerPoint today. We are having some technical difficulties, so Alex and I are going to do just a roundtable back and forth, and we were happy to email you the PowerPoint after. So many of you know me. My name is Kim Christian. I'm one of the partners here. We have multiple locations, Lido Beach, Garden City, Islandia. I work out of the Lido Beach office. And I'm an elder law, estate planning, and special needs attorney. We also help with the administration of a person's estate after they pass away. And I'm really pleased to introduce Alex Nocerino, also an attorney, partner at Chopra and Nocerino, and his practice areas include personal injury, wrongful death, car accidents, slip and fall accidents, and premises liability accidents. And his bar memberships include New York State Bar Association and also Connecticut State Bar Association. Uh, he's part of the New York State Trial Lawyers and the American Association for Justice. So I will say we are in good hands with you, Alex. All
Thank you
right,
very much for having me here today.
happy to have you. All right, so what are we going to cover today? Let's get right to it. Um, when it comes to a personal injury action, what we're outlining today is some strategies for obtaining fair compensation, determining faults and liability, and insights into the litigation process. And then I'll end with how to maintain government benefits in light of this award, because certain, oftentimes some of our clients are people who became disabled because of this. So I think that's a really important facet of it. So just to get started, Alex, regarding strategies for obtaining compensation in a personal injury action, what do you recommend? What does that entail?
So, I often get phone calls from injured people that just got into accidents and they really don't know what to do or where to go or what the next step is. And I always tell them the same thing. They need to focus on themselves. They need to focus on what they need to do to make themselves better. We handle all the paperwork on our end, and they need to just get any treatment that they need, go to any doctor appointments that they need, go get checked up, treat, help themselves get better. We're not doctors. We can't fix these body parts that hurt them, but we can get them money for their pain and suffering. One of the things that's very important that insurance companies look at is when was the first time there was treatment for a specific body part, right? So I'll give you two different scenarios. One where somebody gets into an accident, they say it's not so bad. They try and deal with the pain. They're a tough guy or whatever the case is. And they say, I'm just going to live with it. And then they realize that it's just getting worse and worse and worse. And 2, 3, 4, 5 weeks later, they start seeking treatment. It's terrible in the eyes of a personal injury lawsuit because the insurance companies, the way that they see it is, if you're really hurt that bad, wouldn't you have gone for treatment right away? So um, if you're hurt, if you're in an accident, go seek out treatment. It helps the lawsuit itself, but it's also good for you. You don't know what could be wrong. You could have a fractured vertebrae and it could lead to paralysis and you didn't go and get checked out. I mean, these are terrible things that could happen. So it's a twofold benefit there. Um, the the other aspect of the beginning of the case is evidence. What kind of evidence can be preserved? What kind of evidence can be saved and used and helpful in the case. All right. Um, I want to digress a little bit and talk about the first phone call to the insurance company. So often when people are involved in accidents, their initial knee-jerk reaction is to call up an insurance company and tell everything, tell how the accident happened, tell about their injuries, tell about whatever it is that the other side is willing to listen to. Um, that is probably the worst thing that they could possibly do right after an accident. The insurance companies are not looking to help them. They're not their friend. They'll sound very nice on the other end of the phone. They're recording everything that they're saying. They're taking notes. They're going to utilize anything that they say in the future against them. So they could be speaking to their own insurance company, and that insurance company could then they could ultimately need to file a claim against their own insurance company for benefits, and they could use that recorded statement against them because they try and find and pick up on little inconsistencies. Well, you said you were unconscious at your deposition for 30 seconds, but when we first called you, you said it was 20 seconds. So we try not to give them too many stabs at the apple, so to speak. Um, you're not required to speak to the insurance company. We, as your attorneys, will speak and convey everything that needs to be conveyed to the insurance company. We'll send in all the paperwork, and we'll handle all of that. Again, your sole obligation is to make sure that you're making yourself better. And also, a lot of people are worried about, I need to call the insurance company right away within 2 hours, 24 hours. There's not any time frame that requires you to be in touch with your insurance company within 24 or 48 or anything like that. No specific number of hours. In car accidents, you have to file a no-fault application within 30 days. So that's really the shortest time frame that you need to do something. So you don't have to worry about reaching out to them immediately. That's something that we as your attorneys would handle and call and file all the necessary paperwork. Just segueing into the evidence real quick and going over that. There are several different things of evidence that are very important in a case. In both car accidents and premises cases, you want to try and preserve as much video footage as possible. That could be video footage from inside the vehicle. It could be video footage from the police that arrive at the scene. It could be video footage from nearby stores, restaurants, banks. It could be traffic cameras, at the intersection. So video footage is very important. We send out lots of preservation letters, and when we wind up filing a lawsuit, we send out subpoenas to get this evidence. Also is evidence from the vehicles themselves. We can pull data from the vehicles. We could tell if the vehicle was traveling over the speed limit, things of that nature. And that's more on a case-by-case basis and the necessity of obtaining that information. But the key to preserving all of this evidence at the beginning is very important. That's why you do want to sign up your case right away with an attorney and have them send out all of these preservation letters to make sure that the video isn't deleted or taped over and that the vehicle isn't destroyed or junked for salvage before you get to save this evidence and preserve this evidence.
Okay, very interesting. So I always had a question, and I'm going to ask it because I found what you said about the insurance company and, not rushing to call. Very interesting. What about reporting the incident? I mean, I'd imagine on the scene you'd call right away to report it to
Yeah.
the police. Is that something you do right away? And do
That's
you
something that I
give me
always
the
recommend.
facts?
That's something I always recommend. You should always call the police, report it, document it, have the police come out. The police will do their own investigation. Um, and that's all just as a matter of any accident that you're involved in. The the reporting it to the insurance company is where I say that they
Yeah,
should do it without us and our involvement. Uh,
right.
I'll give you a quick example. You could have somebody that gets into a really bad accident, right? And their ankle is broken and their foot's facing the wrong way, right? And
Mm,
they call up the insurance company and they talk about how they hurt their ankle and they have to have surgery and they're like, does anything else hurt? And they're not thinking about anything else. And they're saying, no, it's just my ankle, right?
right.
But
Right.
meanwhile, their back was throbbing a little bit, and their back winds up getting worse and worse and worse, and they wind up going for back surgery, right? Then they have that recorded call saying, well, you said it was just your ankle. It takes away from the moment, you know, uh, it takes
Fascinating.
away from the actual call that's being made, and it gives them multiple chances to try and trick you into giving different answers. So
Yeah, not,
that's why we always prevent them from doing it multiple times.
yeah. All right. So what I'm hearing in this first piece, and certainly jump in if I'm wrong, but definitely want to seek medical attention promptly. I mean, you said that's your focus, right? Preserving evidence, looking out for recordings, is so important. Being mindful, regarding the insurance company, and always hire an experienced personal injury attorney as soon as possible to help you in this situation. Um, then we get to determining fault and liability. How does that work? I know, some of us that don't practice in this field or don't know about it, we have assumptions that are made, but I don't know that that's necessarily the case. And I know from my law school days, there's all these terms: negligence, strict liability, intentional. You're laughing, I can tell.
Yeah.
And I'm looking, to hear from an expert regarding determining fault and liability and how that should be viewed.
Okay. So generally speaking, on cases, um, unless you make a motion for summary judgment, that's basically asking the court to decide that the other side is liable for causing the accident as a matter of law. So you're not asking the jury to decide it, you're asking the court to decide it. And they only do that in very, very clear instances of fault. Okay. One clear instance, and the most clear instance or example for car accidents or vehicle accidents, is rear end collisions. New York state law is very clear that if you rear end somebody, it's almost certainly your fault. There's a few exceptions. I'm not going to go into them. But if you rear end somebody and you're not keeping enough distance between you and the vehicle in front of you, it is almost always your fault. This is like a 99.9% rule. So we as a firm, when we get these cases and we file the lawsuit, even before depositions, we file a motion for summary judgment. There are two major benefits to filing the motion. One is that takes away one thing that has to even be addressed before the court and before the jury, because you're dealing with this before you get to trial. All right. So that's one big benefit. But the other benefit is if the case doesn't settle, you get statutory interest. So if the case doesn't settle between you and the insurance company and you have to go to trial and you have to try and take a verdict with a jury, whatever the jury awards, you get 9% interest per year from the date you won the motion. So if you make the motion and it takes 3 or 4 years to get to court, you could have 20 or 30 something percent interest that will get added to whatever the jury awards. What does that do? That puts a lot of pressure on the insurance companies to settle. Because if they have a choice, if they're going to take a case and go to a jury, would they rather take a case where they have to pay whatever the value is plus 30 something percent, or a case where there's not summary judgment? So on these summary judgment cases, the majority of them settle. They don't want to go to trial on them. So as a matter of practice, on all of our rear end collisions, we file that motion. Now, there's some other examples where you could file them. One of them is where the accident is pretty clear and it's caught on video. You could file it. So if you see somebody blowing a red light, and it's on video, you could definitely make it. There's some other examples on construction accidents, which is another area of law that we practice. They have very strict laws against the general contractor and the building owners. So if anybody falls from a height, or anybody something from a height falls on the worker, you can file that motion for summary judgment. So there are a lot of instances that you can file this motion, and any chance that you can to actually make the motion, it's very beneficial to you in your case. We often see other law firms that we wind up getting cases that are in the middle of the process where that motion hasn't been made yet, when they could have made the motion. So when we take over files from other firms, so it's something that I think is very important and helps establish liability without even going to a jury. If you do have to go to a jury, so all the rest of the cases where it's not as clear, you want to make sure that you are presenting your case in a light that's most favorable to your client. So you want to make sure that you gather all the possible evidence. If there's witnesses, you want to make sure you get statements from them. You want to find out if they're going to be favorable to you in court. You want to try and get any evidence that you can to help your position. Again, video footage. You could get data, GPS data, all kinds of information you can pull and find and help your case. Also, there's credibility is a big issue, right? Um, you knowing one's credibility and knowing who the defendant is and whether or not they're susceptible to lie or not tell the truth, or they're not telling the truth about this situation or this accident. Going after their credibility is a big thing. We've won many cases where defendants have lied about certain things. We had one where the defendant lied about owning the bar and said that our client made up the whole accident and that he didn't own the bar. And we found a Facebook post on his high school website, and he admitted to owning the bar and that he invited everyone for free drinks.
Oh, boy.
So you can find evidence all over the place if you're doing your due diligence, digging and looking for it.
Okay, great. So another example of why hiring an experienced attorney in this area of practice is so important. I mean, it's these nuances that can make or break a case that are just so important. So, providing damages, right? Insight into the litigation process. I hear things that the economic damages, which I think most people hear about, but there's also non-economic damages and future damages. How are they typically viewed?
Okay, it's a great question.
Thank you.
Uh, the At the end of the trial, when you get to the jury and you're at the end of the case and you have to present what's called the verdict sheet, all right, I actually like to go through the verdict sheet with the jury. Instead of just saying the questions, I actually pull out a copy of it because you've already discussed it with the judge. And I have the verdict sheet and I have the questions. And typically on the damages portion of a trial, there's either two, four, or six questions. And it has to do with past and future, and it's either past and future pain and suffering. That's always on every verdict sheet. And then past and future lost wages and past and future medical costs. So you could have either any of those six questions. It's always past and future
Interesting.
pain and suffering. So those are the six questions that are generally provided to a jury to deliberate on. Okay. And some of them are very easy to compute. You know, if you have somebody that's making $100,000 a year and they had 10 years left of work, okay, their future lost wages is $1 million. You know, if you have $80,000 in medical bills that have been spent so far on treatment, and you have all those medical bills subpoenaed to court, the past medical bills are very easy to compute. Okay. The future medicals are based upon the doctor's testimony. So if the doctor says it's likely the client is going to need another surgery and physical therapy to this body part, and the future medical costs are $200,000, that's what you would rely on for that question. The questions that are not easily quantifiable are the past pain and suffering and future pain and suffering questions. Okay. It's Those are both very difficult questions for anyone to answer.
Right.
Attorneys, skilled attorneys, seasoned attorneys, regular people, lay people, jurors, everyone. It's a very difficult question because there's no book, there's no answers to it. All right. And the different cases have different values, depending on how much treatment there was, how many surgeries there were, how many broken bones. These all factor into the analysis. Future pain and suffering, a lot of it has to do with the person's age. If you have an 18-year-old that has, you know, three massive spinal surgeries and they have a future life expectancy of 60 something years, their future pain and suffering is going to be more than somebody that's already a senior. So you have different degrees of future pain and suffering based upon age. That's a big factor. But I think that having the jury connect with your client is the biggest benefit to actually getting those numbers to fairly and accurately and adequately um, compensate the injured party. I like to give this example because it's something that always stood with me early in my career. One of the questions that they asked my client at her deposition was what, and they ask it at every deposition, is what activities can you no longer do or can you do with difficulty?
Mm,
The worst possible answer a client can give is I can't I can't do anything, right?
right.
You think that that's a great answer because like I can't do anything. Okay, that means that they're in terrible shape. But the person that's deciding how much to award for pain and suffering doesn't actually get into their shoes, doesn't actually get into their lenses and what they're going through on a day-to-day basis. And so I was at a deposition and my client had two failed shoulder surgeries. Now, shoulder surgeries have an approximate value for settlement in the hundreds of thousands of dollars range, not millions of dollars. And again, this was, I don't know, 20 years ago. Um, and she had two failed shoulder surgeries. So they were trying to reconnect and they couldn't, and it didn't work out well. And at her deposition, they asked her, what can you no longer do anymore? And she just started crying. And we took a little break and we came back on and she said she was ready to continue. And they said, what can you no longer do anymore? And she said, well, I take my good arm and I grab my bad arm and I go over to the mantle above my fireplace and I lift my elbow on top of it. And that's where I leave my deodorant stick. I leave it there permanently. And I squat down on my knees and I put the deodorant stick under my arm because if not, I can't properly do hygiene. And then I put it back on the mantle. And then she started hysterically crying again. Okay. This to me is how you get a jury and or an insurance company to really truly understand what it is that you're going through. Okay. That wasn't prepped. I didn't even know she was going to say that. Okay.
Wow. That's
Um,
powerful.
the I felt very strong about the case. I was very passionate about what was going on for her, and the jury came back with 1.4 million on the case. So it's just
Wow.
an example of when you get people to understand what it is you're going through and how it's really affecting you. Um, One of the things that I've learned in building the damages of the case is you have to spend time with your clients. You have to talk to them. You have to have them come to your office. You have to spend time. You have to learn about them. You have to learn about their children and their grandchildren and what activities they love to do. You know, I had a client, I didn't know it until I started really preparing hard for the trial, but he was an avid bowler. He had bowled 300 several times. This is
Wow.
somebody that loves to bowl.
Yeah.
And he's like, he had major knee injuries from this accident. Okay, he had to have a knee replacement. He was rear-ended by a tractor trailer as the back of his SUV was impaled. So, getting to learn the client is the more you know the client, the better you can present the evidence to the jury because you know what to talk about.
Right.
Um, just one last story on talking about picking out evidence. I had a trial in Queens and I was preparing my client. And during the prep, he was telling me a story about how, for his son's first birthday, when they did the pictures, he wanted to go grab his son to lift him up, but he couldn't. And so his wife had to hold his kid, and he got really emotional when he was telling me the story in my office. And when I was preparing him with going over his testimony, I didn't bring that back up again, right? And so we were talking about different dates randomly. What were you doing this day? What were you doing this day? And I just asked him on the stand. I was like, "Can you tell me about, June 2nd, 2019? Can you tell me about that day?" And he just started immediately crying because it was so emotional for him because he had showed me the picture of his wife holding his son.
Oh,
So it
gosh.
was it was very emotional for him because he knew how he felt like he was missing out on his life with his kids. So when you can actually demonstrate what it is that the client is going through and what it is that they're losing out on, that's how you can build up your damages. Getting everyone to understand.
Wow. Your insights are so helpful. Um, we have about 3 minutes left, so I want to be respectful of everyone's time. So I will just touch on my piece very briefly for a minute, and I think we can open it up to questions if that's okay with you, Alex, because I
Of
see one
course.
here already.
All right.
So, Alex is obviously the experienced attorney, and if you need help, you should be reaching out to him. It's very important. And then when all of his piece is done, there's another piece. There's someone that was injured, there's someone that was hurt, and there's someone that now may need a means tested program like Medicaid or SSI, things where it gives them medical care, but you can't have too many assets in your name. So if you end up with this award, what should you be seeing us about? What should you be doing? Right? And there's vehicles out there, legal vehicles that can help you, like a supplemental needs trust, a special needs trust, a Medicaid asset protection trust. And there's all these different variations that can protect your settlement, but also have you maintain or qualify for disability benefits or medical coverage. So if you find yourself in that situation or you know someone who's in that situation, you just want to make sure you don't stop at the award piece. You protect that person so that they can get the care that they need. And we can certainly help with that. So at this point, I think since we have 2 minutes left, let's open it for questions. I can see one here. I'm going to give it to you, Alex. If
Okay.
other if other people are injured in an accident, do you have to or don't you have to call your liability insurer to protect yourself from a possible claim or lawsuit against you?
Okay. So my instructions about not calling them and not reaching out to them had to do with if you were involved in an accident and you wanted to seek an attorney and counsel to get money for your pain and suffering.
Oh, I see.
Uh,
So you were the one that was potentially hit. You were the
right.
injured party. Hmm.
Correct.
Okay.
So if you're in an accident and you're 100% fine and you are 1000% positive that you are not going to pursue a claim for yourself, then yes, you would contact your insurance company and let them know. Now, it, when you're in an accident and you hire us as your attorneys, it's not that you're not contacting them and we're not contacting them. We're going to contact them on your behalf. They are just not getting an opportunity to immediately speak to you directly. All of the communications have to go through us as per our letter. It says, please don't contact our client directly, speak to us. Again, we don't want you talking to them and keep giving them the story and them finding little variations in the story to try and not pay you benefits in the future.
Okay. Very good. Does anybody else have any questions? We're happy to answer. We're exactly 1:30 on the dot. So it seems like, we were able to stay within the confines. As I said, we are happy to send you a PowerPoint that summarizes some of the stuff that Alex and I spoke about. I definitely want to thank you, Alex, for
Thank
joining
you.
us today. I have to tell you, I do a lot of these webinars, and this was very interesting, fascinating, and helpful. This is the real world we live in, and I'm grateful for your insight. On the PowerPoint will be Alex's information, but Alex, if you want to share your website, that would be great if you wouldn't mind.
Yes, our website is chopranocerino.com. Just a quick highlight, we are the official exclusive law partner of the New York Mets and the New York Islanders and UBS Arena. Um, we also, another plug here, we also, at the end of last year, we had one of the largest settlements in New York State. We settled a case for $19.5 million, which we're going to find out exactly where that ranks very shortly on topverdict.com, but it was a pretty big accomplishment for us and for everyone at the firm. My partner and I and everyone here worked tirelessly on the case for many years, and it was a great result. And that's it.
Wow, that's fantastic. And let's go Mets.
So nice.
I love that little fun fact. And then about our law firm, as I mentioned in the beginning, we are focused on elder law, special needs, and estate planning, and trust and will administration. We have three convenient locations: Garden City, Lido Beach, Islandia. We have six partners, multiple associates, and of course, case managers and support staff. So we are happy to help anybody who needs our help, as I know Alex is as well. So thank you for joining us. Have a
Thanks for
beautiful
having me.
afternoon. Be safe out there. And if you need anything from me and Alex, please reach out. Have a great day. Thank you.